Welcome to the news update from Sanyu IP. The recently revised Chinese patent law will come into force on June 1, 2021. One of the major changes regarding patent enforcement are the punitive damage rules prescribed in Article 71. The new rules will allow up to 5 times of normal compensatory damage amount if the infringement passes a two-prong test of being willful and serious. As to the first prong, willfulness generally requires the accused infringer knew or should have known the patent, and a high likelihood of infringement thereof. While we are still waiting for further specific statutes and case law for interpretation, I would say the judgment of willfulness will have a high standard. Eligible situations of willfulness may include repeated infringement after judicial decision, continued infringement after receiving a cease and desist letter, and infringement after licensing negotiations. But merely knowing a patent in a situation not relevant to enforcement will hardly be eligible for willfulness. For example, it may be not advisable for a company to conduct freedom to operate evaluation of each and every prior art patent listed in search reports of its patent portfolio, just as a precaution to prevent willful infringement. As to the second prong of the test, seriousness generally refers to the extent of bad impact from the infringement, which may include whether the infringer does business based on infringement only, whether the infringement exists for an extended period, and whether the economic impact on the patentee or the public interest is substantial. The purpose of introducing punitive damage into the patent law is to raise infringement cost and improve patent enforcement environment. We will wait and see how it is put into practice and affect patent enforcement activity in China.